Good morning, everyone. So Amy's asked if I can just spend 10 minutes with you today just to run through the probate assistance services that Beneficial Trust and Will Company provide. So there are quite a few of you that are already using this service, and we've forged some really good relationships and working really well together. But what I've learned along the way since I became involved, because I'm dealing with the estates and I'm an estate manager, really is just tying up the process for you. I've kind of learnt along the way, along with the people that I work with, that there's just a little bit of tweaking that we need to do to make the process much smoother. So the service we provide is the grant only service. We can provide full administration services as well, but today we'll just talk briefly about the grant only application. So it's a streamlined probate process where if you have any clients that do really want to complete the probate legal process, then you can forward that to us, and we'll work either with yourselves or with the clients closely, and we'll nurture them all the way through. So the main focus really is on successfully obtaining the grant of probate or letters of administration. So the first stage really is obtaining probate valuations. So this is all of the assets and all of the liabilities as at the date that person passed away. And so this is the kind of information that we need you to initially gather for us, or your clients to gather for us. And we have a form, it's a probate questionnaire form, which we ask either yourselves or your clients to complete in full. It's a series of questions. I won't go through them all, but I'm sure if you contact one of the girls in the office, they'll forward you a copy so you can have a look at that. So once the probate questionnaire is completed, we also ask that you forward supporting evidence as well. For example, we need the original copy of the signed and witnessed will. The original copy will eventually be submitted to the court, and unfortunately they do retain that copy. We don't get that back, so it's always useful to ensure that your clients have a copy of the signed will before you forward it on to ourselves. The original death certificate, it's always really important that we do have a copy of that, and confirmation of who's going to act as executors, because it may be in the will we have 2 or 3 executors, for example, and maybe the surviving spouse is an executor, but they're really obviously not coping very well, so they may not want to stride forward and complete this legal process. But if there's a friend or a neighbour or family members, they may be in the right mindset to move forward and be at the lead of the application. Or it may be that there's only one person and they can't handle the legal process at all. So we really need to know from the will the executors and who is acting and who isn't. I'll go into that a little bit more in a second. So if an executor is not acting, if they don't feel up to it, then we have 2 choices. They can completely renounce their entitlement to obtain the grant of probate, or we can reserve power to them. So when we're making the application, we'll select either one of these choices. So when we receive the initial information, so the completed probate questionnaire, the death certificate, the will, we'll need identification for your clients as well. That's then allocated to me for an initial assessment. So we do a thorough assessment and a detailed schedule of assets and liabilities in the first instance, and that's really just based on the information that we're provided with. So what we will do is we'll make sure that there's nothing missing, and if we do find something that's crucial that we do need from you and your clients, we'll pop you an email, or we'll email Lorraine and she'll ask for it for us. I also need to know if I'm going to be liaising with the family, with the client, or with yourselves. And so some of you might want to be quite involved because they've been clients for many years, and I know what we're like in this industry. We're very protective over our clients, and we want to shield them and help them as much as possible. Whereas we may have another where they want us to go direct to the clients because they want to talk to us in case they want questions or anything like that, or they want any clarification. So it's important that I know who I'm contacting if I've got any questions to ask. So once I've completed the initial schedule, the first thing I really do is I forward that to either yourself or the client, just for double checking. It's always good to just stop and have a look and then reconvene, and then move on to the next stage, and then we're not jumping ahead of ourselves, preventing mistakes obviously. So once the schedule's been approved and all the figures appear correct and in order, and all the information on the schedule is in order, we have two choices, and it's two directions that we need to go in. Either one, we can apply for probate by post, and we'll complete the application on your client's behalf, and they will sign the application, and we'll put that together with a will and the other documents that's needed for the court, and we'll submit that application on their behalf. Now this process takes a long time. Paper applications are well renowned to go missing, or they're delayed. So we have a central office in Harlow, and all of the probate applications that are in paper form are all submitted to this one office. So you can imagine, there's thousands of applications, and by the time Harlow have scanned on the application and it's gone to the registrar for their approval, this can be 3, 4, 5 months, so that they do take quite a long time. The other route to applying for probate is by using the solicitor portal. So this is a faster option. What we do is we prepare the probate application, but we forward that onto the solicitors that we use, and what they kindly do is they'll submit the application through their portal. And so when they've submitted the application, what we then do is we'll provide you with a legal statement for your client to sign, and then that will come back to us. Once that legal statement comes back, then we can forward that onto the solicitor for full submission, and we'll forward the we'll forward the will onto the court, the original will. And process at the end of it, obviously what we're wanting is the grant of probate or letters of administration. So once that is received, we've been awarded the grant, we have that in our office. Once that's received, we'll let you know immediately, and that can be forwarded to you to forward on to your client, or we can forward it directly to your client for you. So there are some tweaks when we're dealing with probate. So there's two routes really. There's the long route and the short route. So if we've got an estate under the nil rate band, and for example there's nothing complex in the estate, maybe a property and a bank account under the nil rate band, and no trusts or anything like that, straightforward, then what we will be doing is, obviously once we've completed that schedule and that's all approved by your clients, we've submitted the grant application, we can go straight to court with this grant application, because there's nothing that would indicate to myself that there's any other steps to take. So the easiest route really is submitting the probate application directly to the court. Now, if any of your deceased clients have a trust, not a trust in their will, but if they have a lifetime trust, so a property protection trust in lifetime, asset protection trusts, where they've transferred property into trusts whilst they were alive, when we have this in an estate, even though the property remains in the trust, the value of that property, if the deceased continued to live in that up until his demise or her demise, then that value would be included in the estate for inheritance tax purposes. But even where no inheritance tax is payable, so if we're still under that nil rate band, HMRC will want us to submit an IHT 400 and supporting schedules to them. And that's a process before we apply for the grant of probate. So having a trust in lifetime will trigger the requirement for the IHT 400 to be submitted to HMRC before we go for the grant of probate. Also, if we're claiming the predeceased's transferable resident nil rate band, that again will trigger the requirement for an IHT 400 and supporting schedules. And, goes without saying really that estates that are subject to inheritance tax, same steps as above. However, there's a little step we need to do prior to completing and filing the IHT 400, and that is that we have to obtain an IHT reference number first. And the reason for that is so that our application can be tracked, and any payments that the bank or any investment companies make directly to HMRC for the inheritance tax are paid with this reference number, so it can all be linked together. And also, when we do eventually get to the probate application, the IHT reference number and the unique code will all marry up to let the probate court know that the tax is being dealt with. It's all in order. So these are the curveballs that are thrown in. I mean, there's many more, but the everyday estates that we'll be dealing with our clients will involve what will generally trigger the inheritance tax form submission for most of you will be the need to claim the resident nil rate band, the transferable resident nil rate band, sorry. So I think it's important to note that will trigger this requirement. Now, when we submit the inheritance tax forms to HMRC, what happens now is once they've assessed this and they're happy with everything in there, they will email your client with a unique reference number, and that unique reference number will then need to be forwarded to ourselves because we need that number in order to apply for the grant of probate. So if it's under the nil rate band, we don't need the number at all. But if we're submitting the IHT 400, we do have to wait for that reference number to come through. They used to post it, but now they email it. So we've shaved about 2 weeks off their processing times, which is great. So just make your clients aware that, when they do receive that number, then it needs to be forwarded to us so that we can then proceed on to the next step. So really, just wrapping things up, because it's just a quick run through the process. Just wrapping things up, really, the first step is obtaining the information from your clients. So what they're wanting to do really initially is contacting the banks, building societies, financial institutions, and requesting what we call the probate valuations. So that's the value of the asset or the liability as at the date of passing away. We also need to know what the funeral costs were because fortunately we're able to deduct the value of the funeral from the gross value of the estate. So if there's inheritance tax due, it will mitigate it down. Any liabilities that are outstanding as at the date of passing away will also reduce the gross value of the estate. What people tend to do sometimes is they'll send information in where a DWP's made an overpayment after that person's passed away, and the family have received a letter saying, oh, you owe us £250, for example, and they put that down on the form as a liability, but in fact it's not a liability for probate purposes. that goes on to the next stage, the administration stage of the estate, so it comes into that side. So we have to have a line, and that line is all of the valuations as at the date that person sadly passed away. So our next slide will say any questions, but obviously I'm sat here talking to myself, which is a little bit random. This is the first time I've done this, but thanks to Amy, it hopefully has gone quite well and it all comes out okay for you guys. But if you do have any questions, you know, email them into the office and I'll do my best to answer them for you. And also, if there are any topics on probate and the trust side, inheritance tax, and you know, like anything to do with the probate application and the administration, if there's any topics that you particularly want to cover for your clients, if you let the office know, I'm sure we can put a short presentation together for you. Thank you for listening to me, and again, if you do have any questions, please do let us know. Take care. Thanks. Bye bye.